Yeah. Welcome, everybody, to an episode of Change Starts With Us, Ohio. Today, part two with Michael Bailey. Welcome, Michael.
Thank you.
Let's continue the discussion on pro reform and some suggestions you may have for our viewers.
Okay. Well, after last week, I got in several conversations with people up here about the taxpayer claim idea that I talked about last week, and nobody seemed to know anything about taxpayer claims up here. None of the prisoners did, and most of us, when we do research, we research the things that are of concern to us. And since we're not taxpayers, that's not much of a concern to us. But I had occasion, I thought,
this call is originating from an Ohio correctional facility and may be recorded and monitored.
I thought several years ago that I had a chance of going home, so I was doing research on what I was going to do when I got out. And taxpayer claims came up through my research there. And some of the things that I found out, these other guys wouldn't have a reason to find out. And when I talked to them about it, or when I mentioned it last week, pretty much they threw down the challenge. And when they throw down a challenge about prove your point, you pretty much have to accept that. So
Right.
That's what I did. And so here's the proof on the taxpayer claims and how to go about filing. First of all, outside of ORC 733.59, and this is from Graham versus Lakewood. It's a 2018 case out of Cleveland. It says outside of ORC 733.59, the taxpayer may have standing to sue a branch of government based on two legal theories. One, he is a particular class of people, more narrow than the class of taxpayers generally, that has contributed the funds out of which the expenditures are made. Two, he has suffered some individual injury that he alleges and proves he has suffered damage from, different in character from that sustained by the public in general. Now, there are strategies that I'm not going to get into on an open mic about how to do that, because it involves gathering evidence. And if people know how you're going to gather evidence, then when you do what you do, they're going to be able to stop you.
Right.
So I'm not going to get into how to gather evidence, but these are the things that taxpayers should be concerned about. Federal taxpayers have standing to raise Establishment Clause claims against exercise of congressional power under the taxing and spending power of the United States Constitution, Article 1, Section 8. That's a United States Supreme Court case of Flass versus Cohen, and it goes back to 1968. There's what I call the granddaddy of all cases. That's from 1923. That's Massachusetts versus Mellon. And that says taxpayers lack standing to challenge the act, which involved allegations of misappropriation of funds. Constitutionally, because she had no subject matter interest based simply on her taxpayer status and was not injured or threatened to be injured by the act. Now, you need to know what didn't fly in order to know what does fly. And because that taxpayer did not sustain an injury, then she had no standing to sue. You have to be injured to sue. I mean, that's just common sense. And she tried to file a taxpayer claim without alleging an injury. But the taxpayer claim would have been able to be litigated had she had an injury. The Equal Protection Clause prohibits discrimination by the government, which either burdens a fundamental right, targets a suspect class, or intentionally treats one differently than others similarly situated without any rational basis for the differences. Whether others similarly situated receive different treatment without any rational basis for the difference is called a class of one theory. A municipal taxpayer may allege an injury in fact simply by alleging a misuse of municipal funds. So that case is from the Sixth Circuit, United States Sixth Circuit Court of Appeals. That was a federal case as well. And basically, if you're a municipal taxpayer, you can prove an injury of fact by using the class of one theory. So there are theories that you can use to prove injury, and you have to prove injury to bring a taxpayer claim. And there's a strategy for doing that like I said, I'm not going to get into over an open microphone. Now, how do you do that, the logistical arrangements of filing a taxpayer claim? Well, you file a complaint for declaratory judgment or injunctive relief in the Common Pleas Court of Franklin County, because that's where the parole board has its chief business offices at. So they have jurisdiction. And in that complaint for declaratory and injunctive relief, you have to allege that you're filing it as a taxpayer claim. That gives you jurisdiction on several levels. Now, when you file a declaratory judgment, basically you're asking the court to decide what a statute means and how it applies to you, or what a constitutional statute means and how that applies to you, and what your relationship is to the government agency that you're having a problem with. You ask the court to define that relationship and whether or not you have a right to whatever it is you claim a right to. And that's different than mandamus, because in mandamus, you have to establish that you had a legal right to exactly what you asked for, and they refused it. Here, you're asking the court to define what your legal rights are. So what they call
This call is originating from an Ohio correctional facility and may be recorded and monitored.
So the cognizability is there for a declaratory judgment complaint, but it may not be there for mandamus. That's why you got to go file a complaint for declaratory judgment and injunctive relief on that. Now then, the statutes. You've got to sue the right people for the right reasons. Otherwise, if you sue the wrong person, you're going to get your case dismissed. And the statute you're going to be suing under is 124.34A. And I'm going to read pretty much a synopsis of the statute, because it's about a paragraph long. It says, the tenure of every officer in a classified service of the state shall be during good behavior and efficient service. No officer or employee shall be suspended or removed except as provided in section 124.32 of the ORC, and for incompetency, inefficiency, unsatisfactory performance, dishonesty, drunkenness, immoral conduct, insubordination, discourteous treatment of the public, neglect of duty, violation of any policy or work rule of the officers or employees appointing authority, violation of this chapter or the rules of the Director of Administrative Services or the Commission, any other failure of good behavior, any other acts of misfeasance, malfeasance, or nonfeasance in office, or conviction of a felony while employed in the civil service. So, by wasting tax money like they're doing, that is malfeasance in office, and it's not efficient service. So there are issues there associated with the waste of money that will get people fired. But you've got to do that through the appointing authority. That's the first step in filing your taxpayer claim. You have to file a complaint with the people that you're allowed to file it with. Now, this statute applies to classified service. That means if you're in the unclassified service, it don't apply to you. So who's in the parole board, who's on the classified, and who's on the unclassified? That's defined by statute. 5149.02, the director of ODRC shall appoint the chief of the OAPA, who shall serve at the pleasure of the director and be in the unclassified civil service. So the chief of the OAPA, which at this point is Cynthia Mauser, she's immune from that statute. So you don't sue Cynthia Mauser. The chief of the OAPA is the principal appointing authority who will appoint all officers and employees of the authority except those appointed by the ODRC director pursuant to 149.02 or 151.49.10. So, Cynthia Mauser is the person who appointed the pro board except for the two people that the director appointed. And those people who were appointed by her are members of the classified civil service, and they are under 124.34A. So if the taxpayer is complaining about the waste of taxpayer money, they complain to Cynthia Mauser, and you when you file a complaint, it's got to be factual. It can't just be a generalized complaint. You've got to have facts in it. And those facts are easy to get. The other statute, 5149.10, says the director of ODRC, in consultation with the governor, appoints the victim's representative to the Ohio Pro Board, who shall be an unclassified employee of ODRC. So the chairperson of the Pro Board, I think that's, well, it used to be Tracy Fallheimer.
Yeah.
I think it's
Somebody
I can't
new.
remember who it is.
Yeah, I can't remember neither. I can't remember neither.
But anyway, it's the chairman of the Pro Board that's in the unclassified service, and it's the victim's representative that's in unclassified service. So that makes 10 people that are classified and 2 people unclassified. And it's the 10 people who are in the classified service that are subject to 124.34. Now, there's also some other statutes that you can complain about. And those are the Pro Board is good to say in the interest of justice. Well, they're not the ones who define what's in the interest of justice. It's the trial courts that determine what's in the interest of justice. And that's under Ohio Revised.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
That's under Ohio Revised Code 2929.11. And that says trial courts determine terms of imprisonment consistent with the overriding principles of felony sentencing, which are, there's 3 overriding principles of felony sentencing under 2929.11A. 1, protect the public from future crimes by the offender and others. 2, punish the offender. And 3, promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. So when the judge, and
You have 1 minute remaining.
I'll call back after this. When the judge imposes sentence, he takes into account everything you did, everything that they said you did, and everything that was proven that you did, the victim's impact statement, and then he considers what is the minimum term that he can sentence you to accomplish these 3 overriding principles of felony sentencing. And he comes up with what would impose the least burden impact on state or local government resources. Well, if the parole board is deciding what's in the interest of justice instead of what the trial court said was in the interest of justice, and they're wasting money by these unnecessary flops, these routine successive continuances, that is a violation of the 2929.11.
Thank you for using GTL.
Okay, he'll call right back, guys. And then we'll finish this call. At least I hope he calls back. He's very interesting. As you heard last week, he's very knowledgeable on the law. And we have a big passion on pro reform along with wrongful convictions. Most of you know that I was stuck by the pro board and I was under the old law sentence before 1996. And the pro board just didn't want to release anyone. And they still don't. Unless if it benefits them. I remember a few times when the pro board was under scrutiny for selling paroles. Um, and who knows, that may be happening still today. I'm not sure if anything has really changed, but we'll see. And I like having Mike Bailey on because of his knowledge, his legal knowledge. And he can really walk you through a lot of the steps on appeals and so forth. Maybe he's not calling back. We'll give it a few minutes. Yeah, here he is.
This call is from a correctional
Saved by the
facility
call.
and is subject to monitoring and recording. Thank you for using GTL.
Okay, Mike.
Okay. And we just got finished talking about 29, 29, 11. Now, I want to talk about Lane and Keith. Because I know one of the things that was discussed last week was the unbridled discretion that the pro board has. And I was saying I don't believe that they have unbridled discretion. This is a quotation from Lane versus the Ohio Parole Authority back in 2002. Defendant's discretion at parole hearings is wide-ranging, but it must yield to statutory or regulatory requirements. And that was on page 28 of the Lane decision. That same quote was used in State Ex Rel Keith in 2014 when they ruled that Keith had a right to accurate records in his profile. So the pro board doesn't have absolute discretion to do what they do. They have some limitations on their discretion, but it has to be statutory in nature, which is why I'm giving people these statute quotations, so they know what limitations the pro board has on them. Now, having said that, let's talk about the concept of significant risk or substantial risk. You know, every time you hear about a parole decision, one of the things well, matter of fact, all three.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
All three categories of the new one start out, there is a substantial risk. Well, that's not true. Hardly any of that's ever true, and that's because they don't really know what substantial risk means. Under 2901.04a of the Ohio Revised Code, ORC sections defining offenses or penalties shall be strictly construed against the state and liberally construed in favor of the accused. That means when you read the statute, you have to strictly construe it against the state and liberally construe it in favor of the offender. Under 2901.01a, substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or that certain circumstances may exist. And when you define that even further, you can go back into different case law. And the first one I want to talk about is Miller versus Fisher. It says a substantial risk of serious harm means the risk was so great it was almost certain to materialize if nothing was done. And that's a 2010 case from the Federal Circuit Court, 7th Circuit. The Third Circuit said a substantial risk means a direct relationship between the offense and a risk of violence. And that case was about the use of a gun. And substantial risk of violence was part of the charge. And there was no substantial risk simply by having a gun. Having a gun meant that there was a possibility of a risk, but it didn't mean that there was a substantial risk, and they had to define substantial. Let's see. There was another one here. I can't seem to find it. Oh, we're going back to 5121.07a. That's the new law, the new Ohio Administrative Code statute that they just passed. And that's something else I want to talk about.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
They passed that 2 months after it was proposed. And I didn't see anything and didn't hear about anything on the ODRC website that they were even having a hearing on that. So if they didn't notify people that there was going to be a hearing on that, then why did the JCAR, the Joint Committee on Agency Rule Review, why did they even have a hearing and an improvement? Well, that's a question that you need to ask the people who at ODRC, which is the Legal Services Department at ODRC, what the dates were. And that's public information that you're entitled to simply by asking for it. So you can ask when they proposed the rule, when the hearing was, and why no one was notified. And that's something that they're supposed to tell you. If they don't, then that's, if you're an inmate, because that I can speak of. If you're an inmate, they have to pay $100 a day for not answering it, up to $1,000. Now, I don't know what it would be for a private citizen. Money figures are different for inmates than it is for private citizens. So that's something you have to work out between them. But there is a monetary compensation for them not answering it. And then when you take them to court and make them answer it, they have to answer it and pay you. And pay your lawyer. So that's one other thing I want to say about that. The change that we were talking about, using the unique factors. There is a substantial reason to believe that as the unique factors of the offense of conviction significantly outweigh the inmate's rehabilitative efforts, the release of the inmate into society would create undue risk to public safety. Well, first of all, I've already explained the problem I have with the substantial reason. There is no substantial reason, period. They don't even have an inkling of the suspicion, much less a substantial reason that someone who spent 40 years in prison, or even 10 years in prison, is.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Is the same person who was out there committing the crimes they committed to get into penitentiary. If you've got any type of rehabilitative programming that you can show, and you've stayed out of trouble, then there is no reason to believe that you're the same person, much less a substantial reason to believe, because I've already shown you in the statute, substantial risk means something totally different than what the parole board is using it for. And some of the other stuff that I have a problem with that hold to the law. It says under subsection B, the OPB shall consider any relevant information, including, number 2, the inmate's criminal history, including but not limited to the unique factors of the offense of conviction. In evaluating the criminal history of the OPB shall consider A, official reports of prior criminal record, B, any pre-sentence, post-sentence report, C, the presence of outstanding detainers. Now, if you're trying to judge my current level of suitability for release, why would you go back 45, well, in my case, 46 years, to find out what I was doing 46 years ago? What does that have to do with what I did yesterday? Not much. And it's certainly not going to give you a substantial indication of anything about my suitability for release today. Number 6, any recommendations regarding release made at time of sentence or at any time thereafter by the sentencing judge, presiding judge, prosecuting attorney, and any information received in response to statutory notice provided prior to the hearing. That means the victim and the victim's advocate. Those are your statutory notices prior to the hearing. They go out to the prosecutor, the judge, and the victim's advocate and the victims who want to be notified. Now, nobody checks what they say. Whatever they say, that's what they say. And as far as the pro board's concerned, if that's what they say, then obviously it's a fact.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Because that's what they say. But everybody knows that the things that a prosecutor and judge says, that doesn't necessarily mean it's true. In my case, that's one of the reasons why I filed the habeas corpus, was because there was a bold-faced lie that the prosecutors told in my case to the Ohio Department of Rehabilitation and Correction and the pro board. And that was that I stood over this guy, and while he was begging me not to kill him, I told him that's exactly what I was going to do, and then I killed him execution style. None of that happened. Not any of it happened. And so I got the trial transcript because they substantiated that by saying the victim was talking with his wife over the phone, and the wife could hear everything that happened, and she could hear him begging for his life as the shots rang out. So I got the trial transcript, and I got to the section where the victim's widow testified that she had hung up the phone before anything unusual happened and didn't know what happened. So, number one, the lie that you told about the victim's widow hearing everything, that was a lie. And number two, me executing him is a lie too, because the coroner testified that I shot him twice from a distance greater than 2 feet away. And if I was standing over top of him and I put the gun next to his head and killed him execution style, then that would have been borne out by the forensics, and it wasn't. So we know that prosecutors don't tell the truth in those confidential statements, because I got a copy of this confidential statement. And there it was, right there in black and white, that, I did what he said I did, and that was substantiated by the victim's widow. And they wouldn't give me a rehearing on that. And that's what we argued about in 2017 and 2020.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
And it's what the inaccuracies was what State Ex O'Keefe was about. And the Supreme Court of Ohio in 2014 said, no, if there's an inaccuracy in the file, it's got to be corrected. Well, they were talking, they made that ruling because the parole board had said that he had been violated, parole violated 8 times. He came back to prison 8 times when he hadn't. And so he proved that he hadn't violated parole 8 times. And the Supreme Court said, yeah, you guys got to change that. Well, that was because the parole board is a member of the executive branch, and they don't really, or they're not in the same we'll say country club as the judicial system people. So it wasn't like they were ruling against one of their own when they ruled that way. But they never thought, the Supreme Court never thought that we would be complaining about prosecutors and trial courts and the facts that they was sending DRC that was getting us these super flops and routine successive continuances and all that. And when we started complaining about that, based on the State Ex O'Keefe case, the Supreme Court said, wait a minute. If they don't use the inaccurate information in the Ohio Parole Board decision sheet, then it really doesn't matter because they didn't use it anyway. So if they don't cite an inaccurate fact in the Parole Board decision sheet, they don't have to take it out of your record. Not anymore. Now we come back to the 51-21-107-6. Any recommendations regarding release made at time of sentencing or any time thereafter by the sentencing judge, presiding judge, prosecuting attorney, and any information received in response to statutory notice. Well, they have to consider that. Whether they write it down in the parole decision sheet or not is irrelevant. They are required by statute to consider it. But according to the Supreme Court, it's irrelevant if they don't write it down in the decision sheet. So why are they putting it in the Ohio Administrative Code that they have to consider it? if it doesn't really matter. Number 8, the degree and substance of community support or opposition to release.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
I don't know that much about victims advocates out on the street. I do know about parole reform advocates out on the street. I know they get to know people pretty well. I know that when they talk about old law offenders and new law offenders and parole eligible offenders, they talk from a position of knowledge because they've been around it, they know what the problems are, and they talk intelligently about it by putting forth facts in support of what they say without being emotional about it. Now, victims advocates, they don't do that. They don't know who you are. They knew who you used to be, but they don't know who you are now. So why would victims advocates be in the same section of that along with the people who support you, as though they have as much knowledge about you as the people who do have knowledge about you? I don't get that. Also, people, and I'm going to throw a name out there, Brett Benelker. He's the guy that runs Victims Advocacy out of Lima, and he's been in the newspaper in the Columbus Dispatch. There's an article there about him stopping over hundreds of rolls and all the stuff that he's doing for the victims and how he goes online and runs petitions against people and all this. Well, number one, if you're signing a petition online to keep me in prison and you don't know anything at all about me, why would that have any significance whatsoever to the parole board? Because someone in a community that I'm not paroling to, that I didn't commit any crimes in, that probably wasn't even born when I started this prison sentence, because they signed a petition, an online petition, to keep me in prison. You're going to use that as a reason for keeping me in prison. That doesn't make any sense. The people who you should be listening to are the people who know me now, not the people who knew me 46 years ago, and not someone who not only doesn't know me, but is being, I'm not going to say manipulated or controlled, that's not what I mean, but they're being led into signing a petition, and I don't know what the motivating factor is for them doing that. Whether it's because they have a victim in their family, or they've been a victim themselves. You know, I have no idea. They may have legitimate reasons to sign the petition. But if it's to just go along because you're walking down the mall and you're with your girlfriend and someone says, hey, will you sign this petition? And she signs it, that's not a good reason for you to sign it yourself. And same thing if you're sitting in the living room and you see it online and there's signing up for it, you know, in your house. There should be a reason for you doing what you're doing. And that should be part of you opposing or supporting someone's parole. Number 11, adequacy of inmates' reentry plan or prospects for release to include C, physical and mental health as they reflect upon the ability to perform a release plan and comply with the conditions of release. D, family and support system. Now, when I first started this prison sentence, I was 19 years old and top physical condition and top mental health. And I'm still in pretty good mental health. My physical condition, after 46 years of incarceration, I've had 3 discs in my lower back that I've gone through. And I'm not going to be out there working 8 hours a day in some stand-up job in a factory. And I'm not going to be doing anything physical like shoveling snow or the things that you would normally have to do to maintain your house. Probably not going to be doing that on a regular basis because
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Prohibits me from doing that. As far as families and support,
You have 1 minute remaining.
that was one of the reasons why I got a continuance, was because I listed 4 halfway houses. Well, in 1989, did you say something?
Well, did you want to call back again?
Yeah, I'm going to call back one more time.
Okay, sounds great.
Okay, but in 1989, I had a fantastic parole plan. I was 34 years old. I was going to parole to my 27-year-old girlfriend who had 2 children, and we were going to get married. I had letters from 20 different businesses in Columbus that wanted to hire me, literally 20 different businesses that I had become acquainted with as a road driver when I was driving all over the state by myself, unescorted. They got to know me as a road driver, and they figured that since the prison system trusted me to get the keys to a truck and do pickups and deliveries, then
Thank you for using GTL.
Okay, he'll call back one more time. Mike Bailey has been down 46 years. And they keep denying him parole. He is a changed person. He's taken every program that anyone can take while you're locked up. And the parole board, I think, one reason won't parole him is because he's pretty smart. And, you know, when you file different motions and stuff, you know, they don't like that. But our people deserve a chance, you know, and deserve a fair hearing at a parole hearing. I know some guys, you know, those sentenced before 1996 go to the parole board 2/3 after their sentence. Those after go day for day of their minimum. So say if they got 15 to life, they have to do all 15 years before they see the parole board. You know, so there's a little bit of a difference going on.
This is a prepaid debit call. This call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL.
okay, continuing where I was when I left off. 1989, I had a fantastic parole plan. I got a 5-year flock. 1994, it was great. I was at Lucasville, but I still had places to parole to and jobs to go to. I got a 5-year flock. 1999, it was really pretty good. I was 25 years in the pit. I didn't have as many people wanting to hire me, but I had some. And I still had my sister's house to go to, so I had a place to go. I got a 5-year flock. 2004, it was good enough to get me parole. Well, the parole was taken from me 4 days before I went home when the victim's widow complained about me getting out. And they gave me a 3-year flock. In 2008, it was good enough to be recommended for parole again. That recommendation was denied at Cobra, and I got another 3-year flock. In 2011, it was a non-factor. In 2014, it was a non-factor. In 2017, it was a non-factor. But in 2020, it was cited as too inadequate for me to be paroled. Now, if you're going to keep me for 45 years,
This call is originating from an Ohio correctional facility and may be recorded and monitored.
the resources that I had to parole to and the people that were going to help me, family members, they're going to be incapacitated themselves. If they were older than me to begin with, they aged the same, well, probably worse than I did in the 46 years I was in prison, because most of them passed away. And so when you talk about the family and support system, you have to temper that with the reality of the situation, which is a lot of guys outlive their family and support system in the penitentiary, and that's because you keep flopping us. And if you had let us go, like if you let me go when at my first hearing, like you should have, then I would have been probably retired by now, and I would have paid taxes over the last 30 years instead of been a tax burden over the last 30 years. 12, age of the inmate at time of offense, and it got diminished culpability of youth. Now, I understand that your sense of moral development isn't fully developed until age 25. But people that are under 18 years of age that can't even vote or buy cigarettes or do any of that stuff, who get these cases and they're tried as adult, sent to adult prison, I can see that, maybe they were the ones doing the influencing, because when I was 12 years old, I was out robbing people doing the influencing. So I can see where someone under 18 could be an influencer. But if they weren't, if there was someone else that was an influencer in that case, they shouldn't even have been tried as adults, much less come to the adult system and get a continuance, because, well, let's face it, you flop everybody with an aggravated murder case the first time. So why would you automatically continue someone that came in between 16 and 18? That doesn't make any sense. So I see the 16 to 18-year-olds. 18 to 21 is a different section of age category. Your moral faculties are not fully developed then, and maybe you're living at home, maybe you're not living at home. There's a lot of factors to consider, but if you were between 18 and 21, it should be a substantial impact in favor of release. Whereas if you're under 18, it should have a controlling impact. Now, the 21 to 25 category, that should have a positive impact as well, because psychologists.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Psychologists have known for years, practically decades, about your moral development and how it kicks in around 25. So if you're under 25 when that crime was committed, that's one of the things that should count in your favor, not against you. The family and home environment at time of offense, that's number 13 on the list of things that they have to consider. Now, let's think about that for a minute. 46 years ago, I wasn't even living in my family's house. And so the family and home environment, what difference did that make at all? Why is that even a factor that they're going to consider 46 years later? If I was living at home with my parents and other siblings, still, what difference would that make? I mean, people who have been in the prison system for any length of time, they're not going to be influenced. The reason why they committed a crime, now that might have been a factor, but the person that they are today is not the same person that they were when they committed the crime. That's just a fact of life. People change as they come into the penitentiary. And most of us get better. Otherwise, we'd all be at Lucasville or Youngstown. And since most of us are places other than Lucasville or Youngstown, then obviously we're changing for the better, not for the worst. And that's just something that the parole board's lost sight of. And when you think about it, when Governor DeWine got elected into office in 2018, he took office in January of 2019. And if you remember, Shirley Smith made her revelations about the parole board in December of 2018 and quit. And then the newspaper articles came out in January of 2019. And Governor DeWine said that he was all for parole reform and he was going to work on that. And then Fair Treatment Reform and Reentry, they put out a bill with Beverly Seymour, and everything was, moving right along. Then the COVID didn't kick in until March of 2020. So between January of 2019 and March of 2020, what did the legislature do other than increase the amount of time that people have to serve in prison for first, second, and third degree felonies? That happened in March 22nd, 2019, when they created another class of prisoners in the state of Ohio. There's at least 4 classes of prisoners in the state of Ohio now. It's no longer old law and new law. You've got the really, really old law guys that are here from the law as it existed prior to House Bill 511. that took effect January 1st, 1974. Then you got guys like me who are the old law offenders that cause of cases after House Bill 511 changed the revised code significantly. Most of the sentences before that were like 1 to 5, 5 to 10, 10 to 20, and 20 to 40. And then when House Bill 511 came in, 1174, then it became like 1 to 5s, 3 to 10s, 5 to 15s, and 25 years was the max. 7 to 25 years was the max at that time. And life went from 20 years to the parole board prior to January 74 to 15 years to the parole board after January 74. And that was because of testimony from psychiatrists that said 20 years was too long. 20 years, people, you start getting diminishing returns from your rehabilitative achievements. And so they shortened the time from 20 years to 15 years for parole consideration. And they were kicking people out after 15 years instead of making them do 20. So you got the super old guys, then you got the old guys, and then you got the Senate Bill 2 guys from 1996. That's where you got the flat time people coming in. And then here in 2019, you got the new law guys. And that's when
This call is originating from an Ohio correctional facility and may be recorded and monitored.
that go to the parole board after the stated term of their imprisonment. Say you come down with a 2-year sentence, like my buddy does, and you go to the parole board with a presumption of parole. And you still have 1 year left to serve because your sentence is from whatever the stated term is to whatever the stated term is plus 50%. So he has a 2 to 3 that he's down on, and you'll see the parole board after 2 years with a presumption for parole when he sees them. Those are the new guys. So you've got 4 different classes of prisoner in the state of Ohio now, 2 of which are going to go to the parole board. The new law guys, which is the people like my buddy with 2 to 3 year sentences, 4 to 6 year sentences, and things like that. And then you got the parole eligible people, which are all lifers and people prior to July 1st, 1996, within the term of the census. And the parole board is going to see both classes of people. One class of people, they're going to have a presumption of parole when they see them. The other group of people, me and the people like me, there's not going to be that presumption for parole in our favor. We're going to have to suffer whatever we have to suffer because they have a presumption of parole. And therefore, if they don't get a parole, they can challenge that in court. And if we don't get a parole, then we're going to have to find some other thing to do. And so that's where we come in with the taxpayer claims and the lawsuits and the proposals and the bills and all that other stuff that we've been trying to do for the last 40 years. And there's not much else we can do except continue doing what we are doing because there have been some successes. And some of the successes that I want to talk about are like Kinney versus Moore. He's the guy that I was telling you about last week. That the parole board, when he complained about them lying to the legislature, the parole board said, well, there's no law says we can't lie to the legislature. And the judge says, oh, no, you can't do that. And so he defeated their motion to dismiss, and he's working on money damages right now, and he's been paroled. And then you got Steve Gumble back in the 80s. A lot of you guys.
My old cellie.
Steve Gumble.
Yeah, he was my cellie.
There you go.
Yeah.
He successfully litigated his release, but he took the deal. And as part of his deal, the lawsuit was done. And his lawsuit was the racial allocations of parole. And he got the Ray Capons, who was chairman of the parole board at the time, to admit that we flop white people more often and for longer flops in order to maintain a racial balance. And the reason why they needed to maintain a racial balance that way was because that was back in the 80s with the upsurge of crack in the inner cities spreading to the suburbs. White kids from the suburbs was coming into the inner cities and buying crack from black inner city youth, and they were putting the black inner city youth in prison for ungodly amounts of time and letting the white suburbanite kids go. And so they had all these black kids from the inner city coming in, and the white kids from the suburb that was buying all that stuff, they just let them go. And so they had that influx of crack dealers that came in, and of course the gangs that they ran in. And so they was maintain a racial balance by giving white people longer.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
And Steve had the statistic to prove that. And when he put them in front of the court, break a boss, he'd been doing it for years. He says, yeah, we do it that way. Well, as soon as he admitted that, they demoted him from the chairman's job to a regular pro board position, gave Gumpel a new pro hearing and let him go and defeated his lawsuit. But he overcame the motion to dismiss, and he wrote a book about how to sue the pro board. Rhonda Head, she's another person. Her lawsuit was filed by some attorneys, and when they defeated her motion to dismiss, and they got to the discovery stage, the pro board said, we don't want to reveal the secrets that we have, so we'll just let her go. And because they let her go, that defeats the lawsuit. And you don't have to do anything after that. So you've got people that succeed, but when they succeed, they defeat the lawsuit by letting them go. And if there's no case or controversy, then it's not justiciable. And justiciable means that the relief that you wanted cannot be granted because it's not available anymore. And so when people are asking now what they can do, a lot of lawyers won't take an inmate case against pro board because more often than not, they lose. And they lose mainly because they don't do the taxpayer claims or the declaratory judgments and things like that. So if you go in on declaratory judgment first, and that's a lot of work, it's going to take a lot of time, it's a lot of research, and if you succeed, the best that you can hope for from the attorney's point of view is to get compensated for your time and effort, number one, and your client will be paroled and they'll defeat the case that way. So that's one thing that people can do is consider finding a lawyer that will file a case in the common police court for on behalf of people that they had in prison. And I told you
This call is originating from an Ohio correctional facility and may be recorded and monitored.
statutes that could be used. And I mean, like I said, I had one going on behalf of another guy, and he died. And when he died, so did the lawsuit. And I was looking for another guy, and you just have to find that right guy. Because when you get a flop, if they can justify it some other way, and it's justified, like excessive RID tickets, or I don't know, you came in without a GED, and here 30 years later you still don't have a GED, and lack of programming, that would be another justification. Then, you know, there's some type of reasonable argument that the pro board can make. You're going to lose the judgment. So you got to find the right guy. And so I would suggest that people who have loved ones in prison, tell them stay out of trouble, number one. And number two, make sure you're programming whatever you can take and complete. Take it and complete it. That way you establish a record of rehabilitation. And if you don't have job training, get job training. It doesn't matter if you're going to get a job or not. What you need is training. What you need is a piece of paper saying you went through the program, you jumped through the hoop, and you did it because you want to go home, and it's going home is so important to you that you're willing to do that. And as long as you have all these certificates and stuff like that, you have a issue to make in court about your continued incarceration and the fact that they're wasting taxpayer money by keeping you in here. If you don't have all that stuff, if you spent your time, playing pool and chasing, whatever it is that you want to chase, and you don't have that certificate or whatever it is that what the parole board wants, I don't know if you're going to have much of a case to make. So, like I said, my suggestion is have your loved ones get that stuff, because the more paperwork you got, the more likely it is you're going to succeed in court. And when you start filing informal complaints and tickets or grievances and kites and stuff like that, write it up as though you're going to use that as a piece of evidence in court. And you can put the facts in there that you need to put in there. And if they fail,
You have 1 minute remaining.
if they fail to address the facts, that's an addition. Do you want me to call back? I can call back one more time if you want me to.
Sure, that would be fine.
Okay, and I'll take questions after that.
Okay.
There's some other stuff I want to talk about, but I'm sure people have questions that they want to talk about. And I don't really like to monopolize everybody's time like this. Even though I think if they recorded this, that they got those statute numbers, and they got the information on taxpayer claims,
Right.
things like that, that might benefit them to a pretty good extent, because a lot of times when you start gathering your evidence and you write things down the way a lawyer's going to write it down, they're going to look at that and say, this guy's got something on her mind, or this girl, or this necessarily have to go down. But we may have to do something with this guy. And
Thank you for using GTL.
It'll go right back as you heard. If you have any questions, please mark it down there, or you can inbox me on Facebook and see, that we could ask Mike Baylor when he calls back. He's very interesting though, and he knows his stuff. So if anybody is on it that has any questions regarding the parole board, please let us know. I'm having trouble seeing some of them, but
Hello. This is a prepaid. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using GTL.
okay, I'm back for questions.
okay. So far we don't have any. People have said that they were very interested in what you were talking about. I don't think people knew about the different laws that took effect since the 70s through the 80s through the 90s.
It was from pre-1974. That was one group of laws.
Right.
And there's a bunch of people in the hunter camp here, right beside us. They're from that era.
Yeah, and I was I was only 11 years old back then.
Well, I was 18, but I wasn't
Right.
convicted of any crime back then.
Right.
My crime, I was convicted of my crime in December of 74. So I fall under the House Bill 511.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
So it goes pre-January 74, post-January 74, up until July 1st, 1996. And then July 1996, up till March 22nd, 2019. That's the third group. And then the newest new group is after 2019, after March 22nd.
Right.
So you got 4 different categories of inmates. There's no longer just old law, new law. I would suggest that when people talk about parole board, you refer to us as parole eligible inmates without a presumption of release, and parole eligible inmates with a presumption for release. And there is a distinct difference based on when you were convicted and what you were convicted of. If you were convicted of a first, second, or third degree felony that was committed after March 22nd, 2019, you fall under the new law category. And when you go to the parole board, you'll have a presumption for parole. But those of us who go to the parole board with crimes that we were convicted of before that date, we don't have that presumption. We got the same presumption that we've always had, a presumption of getting kicked in the ass and having our neck stepped on.
Okay. We do have one question.
What's that?
It says, if you could change just one thing, what would it be regarding the parole board?
If I was, one thing is kind of limiting.
Yeah, I know.
You have to have oversight. No matter what they do, you got to have oversight that's capable of correcting it.
True.
And if the oversight you've got isn't capable of correcting it, then you don't have oversight. So I would say that the one single thing the legislature could do to better things for parole eligible offenders is to create some type of oversight over the parole board. And if a parole board member is continually giving people routine successive continuances based on outdated information and the criteria that I went through today, then that person doesn't need to be a parole board panel member. 124.34A kicks in at that point, and they should be fired from the job. And you hire someone who will do it. That, to me, is the type of oversight that they need. Now, the oversight that they have right now is their appointing authority, which is Cynthia Mauser appoints 10 people who are in the classified service, and Jeremy Smith appoints the parole board chairperson and the victim's advocate on the parole board. So those two people are not bound by 124. But if you had oversight, then you could fire them people too. And they wouldn't need to be under the 124.34 section. You could just fire them for cause because they're at-will employees.
Yeah, well, I think Cynthia Mauser has to go for any changes.
Oh, no, she's not going to go. She was a champion of the system that we have now.
I know.
I mean, why would she want to change anything?
No, I'm just saying,
Probably one
yeah, I'm saying we got to get rid of her for any change.
Oh, yeah. And matter of fact, Shirley Smith said the same thing in 2019.
Yeah.
In January when she quit.
Yeah.
And she started doing the newspaper interviews and all that.
Then when she lost for mayor, she no longer wanted to help, and she was part of the problem.
Yeah. Well, she was upset. And
Right.
so she spilled the beans because she was upset. And then when people wanted her to make a difference, I think it's just like what's that guy's name, Larry Householder.
Yes.
People don't have $61 million to give to legislators like First Energy did. We're nowhere near that capability. And if we had $61 million to give to somebody, we might be able to get something passed too. But we just don't have that.
Right.
That's how First Energy got their $1.5 billion subsidy from the Ohio taxpayers, was to give Larry $61 million up front to get it done. He got it done. And then he got caught.
Right. Uh, it's sad all around, though, that people play with your lives.
Oh yeah, I'm not disputing the tragedy that the pro board inflicts on people, and I don't know if they do that because of sense of moral superiority or whether they have some type of financial incentive for doing it. I just don't know. If I was out there and I could investigate their lives like they investigate.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
I'd be able to tell you what they do. Now, I'm sure a lot of people knew Mike Jackson used to stop off at the bar before he went home.
Yeah, and selling paroles.
Stop off at the bar. And I mean, drunkenness is one of the things under 124.34 that you can be fired for.
Right.
Well, he tried to play it off as though he worked for the governor when the highway patrol officer pulled him over, and it didn't work because he was dealing with someone who didn't care about who he worked for. And but unfortunately, if he did it then, he'd probably done it several times before that. But there was all kinds of people who knew that Mike Jackson would stop off there and get dry, and probably would stop up at the bar on his way to work.
Right.
And nobody made any comments about that. There was that collegial atmosphere in the pro board that you don't see anything, you don't hear anything, you don't know anything, but parole is denied.
Right. It's. Do you see any changes in the near future?
Well, I see the changes get worse. I see that. I know when the first change to 5120-1107 came out, they were changing instead of unique factors of the offense, they changed it to overwhelming community opposition far outweighs that, and they was using community opposition like they're using unique factors of the offense now.
Right.
And so the director, who when she got in office, she said she was going to make changes in the parole board too, and all the changes that she's made don't seem like they're for the positive. They seem like they're for the negative, and because they seem to overly vilify people that have been in prison for a long time, and they skew their decision-making criteria against them by saying your parole plan has to be workable, and you've got to have places other than a halfway house, things
Right.
like that. Well, a lot of us don't have that. I'm 65 years old. I'm going to go out there and I'm going to get some type of Social Security and a cheap apartment, and I'm going to be going around pretty much doing what I'm doing right now, talking to people and trying to keep people out of trouble, pulling their eyes open to what the system is, and letting them know that pretty much everybody who runs the other side of the system is a lot smarter than you are. And they've been sinking people for decades. And someone who's new to the system, who don't know anything about the law, you're going to get convicted. And you're going to go to prison. And you're going to be there as long as they want you to be there if you continue to do what you're doing. And people need to hear that from people like me. Because when I talk to them, I don't talk to them and say, don't do as I say, do as I do. That's what I tell them. Just look at me as an example. And tell my story, and it has the ring of truth because it is true. One of the reasons why I don't lie is because I can't remember a lie. They've always been too difficult for me to remember. So either I'm going to tell you the truth or I'm not going to tell you anything. And that just seems to be a system that's worked for me over the decades that I've been on the planet. And so when I do talk, I tell them in language that they understand, that they can relate to, what they have to look forward to, and let them make a choice. If you want to do 10 years in the penitentiary and get out for a couple weeks or a couple months and then go back in the penitentiary and do another 10 years and then get back out. I mean, you can do that. People do it all the time. They don't have much of a life, but they do that. And, they do get out of occasionally. But you need to not get out on vacation. You need to get out on a staycation and stay home. And a lot of people, when they get older, that's what they try to do.
Oh, wow. Let me see if there's any more. No, you got a lot of people watching. But
okay. I do want to talk about this proposed bill that's floating around in here.
Okay.
You remember us talking about it?
Yes.
There's a heading on it. It says a proposed bill to reform Ohio parole release law proposed to the Ohio General Assembly by a coalition of supporters, friends, and family members of Ohio prisoners who are subject to parole release decisions. That's the title of the proposed bill. And then it's 10 pages of a well-written presentation. I mean, I like the way
This call is originating from an Ohio correctional facility and may be recorded and monitored.
and a lot of the ideas are ideas that were in the same proposal that Fair Treatment Reform and Reentry submitted. But there are some other ones as well. And I've read it one time. I haven't taken any notes. I will take some notes because I want to talk to the people who did it, but there's no indication on the proposed bill who did it. So I don't know who to contact. And I'm asking whoever does know the origin of this proposed bill, have them send me an email so I can get in touch with them.
I will check around. Yeah.
And because there's ways to punch this up to make it a lot more substantial than what it is. And even just by using the statute numbers that I gave you tonight, that when you use the law to support the proposal that you're making, laws that are already laws that support exactly what you're saying, then you should put that in your proposed bill. Because that's information, when you submit a proposal, basically you're asking the legislators to write a bill based on your proposal. And if you can show them where you're asking for a supplement to the law rather than a change of law, then that's going to be more in your favor because that's easier to accomplish. And a lot of the things that I talked about tonight are mandatory things that the parole board's not doing. And if we could just get them to enforce the law that exists already, we'd be over halfway there.
Right.
A lot of these proposals. So that's why I want to talk to the people who wrote the bill to see if I can see if they would want me to add anything to it and send it back to them. And if they want to go with what they got, then by all means, I'm of the opinion that the more the merrier. And if there's a lot of great ideas in this proposal. Matter of fact, I don't see anything that is objectionable. And so I support what they're doing. I support how they're doing it. And I would like to add something to make it better.
Great. I'll check around. I'll ask some of the friends that I know that help on parole reform, see if they know. But, there's a lot of people that really care to see change take place. But if we don't educate society, they're not going to understand why we do it.
Yeah, and I think and it's not an issue with me, but it's an issue with some of these guys. A lot of these guys, they think that it's the emotional strings that are going to get people interested. I don't see it that way. I think people on the street that don't have loved ones in prison, they don't care until you make them care by showing them why they should care. And the way you do that is to show them where there's such a waste of taxpayer money that
This call is originating from an Ohio correctional facility and may be recorded and monitored.
the $119 million a year that they waste on over-incarcerating rehabilitated offenders It may not be used to fix bridges and underpasses and stuff like that, but it could be used for law enforcement initiatives in your neighborhood. I don't know what kind of neighborhood most people live in, but I'm sure if you live in a crime area, you would like to have one of those anti-crime cameras on a light pole, so the criminals in the neighborhood would look at that and say, well, my face is on camera, so I can't go around this place. I can't do that here. And have some protection.
Right.
But that takes money. And so when you're talking about protecting society, you're not protecting society from people like me, because I'm not a threat to society. So my incarceration doesn't protect society. My incarceration threatens society, because the money you're wasting on me is not being spent on these law enforcement initiatives that would protect you. And when you approach the problem from that direction, you get more people's interest because they see the reasonableness of that argument. Whereas if you say, oh, you've kept this guy in prison for 40 years and almost every member of his family's died and it's time to let it go. Well, a lot of people would look at that and say, well, he's not related to me. I don't know that guy, and not be concerned about it. But if it was someone they were related to and someone that they did care about, then that would have an impact. Money is going to have an impact on everybody.
Right.
And because the tax money that they're wasting is tax money that could be better spent helping them. And especially now with the COVID-19 the way it is, and people in dire straits and financial straits. I mean, it's at a point now where the financial argument could be persuasive if it's used in such a way. I'm sure they've got anti-taxpayer groups, like they've got pro-reform groups out there.
Right.
Network with them, network with those guys and find out if they are working on this waste of taxpayer money. Because
Right.
you've got anti-taxpayer groups that have senators and legislators in their pool of contacts.
Right.
These are people that could be on our side.
Right. Well, that new bill that you mentioned to me, that sounds awesome, and
You have 1 minute remaining.
I would like to get you back on in a few weeks, if that's okay.
Well, you got my email address.
Yeah.
And, so
Maybe after you get a
chance.
chance,
Next week.
right. Maybe after you get a chance to read that bill, we could kind of let people know what it's about.
Yeah. Well, I've got the address. I've got your address, so I can send it to you.
That would be great if you could.
Well, I
And-
get some copies of it tomorrow.
Okay, and
When we do, I'll
okay.
drop a copy in the box.
okay, and let us know how we can help if you find anything out through it.
Well, you can help by contacting these anti-taxpayer groups and thinking about these taxpayer claims. And when you encounter a bad state employee who's giving you a hard time.
Thank you for using GTL.
Okay, that was Mike Bailey, everyone. Thank you for joining us tonight, and we'll be back on soon.